What is up, Gorgeous George fans? It's me, Marty McFly, your Swedish attorney at law, bringing you the latest news from the Virginia courthouse. Guys, let's dive straight into it. Handwriting. Ridiculous. Ridiculous handwriting. Motion for reconsideration of time, number 2. In relations to case number, I previously requested an extension and it was denied. This case is one of a serious matter and I need to obtain attorney pertaining to this case. I'm asking for just one more week on this matter to November 16th for preparation of and defence. Fucking hell, man. Just fuck, you're 50 years old and you can't use fucking Word properly, for fuck's sake. I will have an response in full if I can be granted just 1 week more, since this is a very sensitive matter. I'm trying to get every aspect of this case soaked in with a good, positive defence, which means an attorney might be needed. So, at one point, he's saying he needs to obtain an attorney, and in this point, he's saying, I might need an attorney. I respectfully ask this, and your understanding in the matter, respectfully yours, Gay. Essentially, guys, this is George's case against the bank. He's asking for yet more time to try and file a defence, even though he's had plenty of time to do it. And if he had a defence, he'd be able to do it. It is just nonsense. The bank, the court will not allow this. I can't see it happening in any way, shape or form. That's a nice quick one, but this is the doozy, folks. Yared plaintiff versus Brennan et al. Motion for reconsideration for amend. He's using Word, okay, and he still is printing stuff with mistakes in it and then having to correct it. And again, as Sean said, why not use some whiteout? Or you've printed it, just go and print it again. Or can you not afford the printing? Defamation complaint to proceed. Answer to 69. In relations to case number I, the plaintiff, George Yared, respectfully request the courts to amend the complaint of defamation to proceed for the following reasons, also stating history of the case thus far. History. After the first particularised complaint was made, certain exhibits were left off and added in the second particularised complaint. When the harassment tort was dismissed in the third particularised complaint, it was amended to defamation, slander, privacy. So George still hasn't read the order that the judge gave him, which is, I've dismissed this, you can't just change it and then make it the same case again. Just recently, this was dismissed, only leaving copyright claim. Now I proceed in motion for reconsideration in this matter. Reasons why the amended complaint should proceed. This case's strongest suit is the defamation. That's an important thing to remember here, guys. The strongest point of this case is the defamation. That means George knows the copyright case in this case is not strong in any way, shape or form. And I cited every transaction and event that happened, like in thick novel of a solid book of defamation torts, to light up Christmas tree. What the fuck is he actually fucking saying? Let's just read that again. And I cited every transcription and event that happened, like in thick novel of a solid book of defamation torts, to light up Christmas tree. Ridiculous. In one's opinion of my work not being of a masterpiece theatre or of low-budget works is one thing, and or not liking it. Though simply not liking it can't diminish the claims of the merit of defamation within the case. So he's basically accusing Judge Gibney here of saying, oh, just because you don't like it, that's why you're dismissing the defamation case. No, he's dismissing it because it's incorrect, you buffoon. You absolute buffoon. There is enough evidence in the prior exhibits given and samples to prove of an substantial amount of defamation and privacy throughout the case that was filed. I respectfully ask the courts again to review evidence for which is boldly evident. They've reviewed it, and they said it couldn't go ahead. It was dismissed with prejudice. Understand what the court are telling you. Newer developments within the case to support defamation. Check current exhibits given. Check link on Facebook filed with new claims and torts made about the plaintiff. This has been created by Will Markland. That group was not created by Will Markland, and I can 100% attest to the fact that that group was not created by Will Markland. And anonymous character Marty McFly. I am not anonymous. I do exist, and I am a real person. So there you are, George. Another fucking factual mistake you made. Facebook channel filled with pictures of my house and telephone number listed, filed with more slanderous libelous throughout the channel. Okay, so first of all, Facebook is not a channel, it's a page or a group, completely different to YouTube. And he just harks on about the most ridiculous nonsense that he ever could. It's just ridiculous. RVA Dirt. So this is the article that was published by a news outlet that George has managed to get them to retract. He then tries to link to some screenshots here because whoever's done this is a buffoon and there's no evidence attached to this. These are samples of posts from these people on this community of trolls. This was created by Will Markland spreading falsehoods. Will Markland did not create that group. To the Comcast station where I do my show at, that I was misogynist. It's proven that you're a misogynist. We've proven it over and over and over again that you're a misogynist. Racist. We've proven it over and over and over again that you're a racist. And have a slew of restraining orders from women that have been made on me. It's been proven that you've had restraining orders made against you from women. Another post stating that I pay for call girl services. We all know you pay for call girl services, and we all know that you're sending money to prostitutes who are currently in prison, George, and you support them while they're in prison. That is a fact that everyone knows about. Vile and disgusting, which is libelous, that proves my current claim of defamation. No, it doesn't. This defamation is ongoing and seems like it doesn't and won't stop until something is done about it. These posts have been forwarded to Mayor LeVar Stoney to his Twitter account and to the local CBS network, Channel 6, trying so desperately to get my show removed from local public access channel like they did to my radio show. These events continue with no consequences being accessed. His pleadings make no sense for the wrongdoing, piling up with more distorted taunts and defamation to my character and name. Ongoing YouTube channel, which this doesn't link to any YouTube channel, under the sock name and anonymous name Marty McFly, a fictitious reference to movie character tied to the current Facebook channel, which is created by Will Markland, defendant in this lawsuit. Will Markland did not create that Facebook group. He did not create that Facebook group. So get that out of your head, you fat fuck. Conclusion. I've stated claim for harassment, privacy and defamation. These are valid claims and the abuse is still going on. The proof is in the body of torts and in the ongoing works of malicious predatory attacks, not to mention my telephone number being called at all hours of the day and night. I refuse to have to change another number in which I had to do 12 times in the span of 10 years due to this unhealthy behaviour from these mentally ill and mentally challenged people. I respectfully conclude that once again that my show and ongoing character should be separate from dealings in the real world. I respectfully request the amended defamation to proceed as previously requested and asked for in this case. The evidence is here within the body of the complaint and case. Respectfully conclude of the defamation issue for the case to proceed with the same stipulations of monetary and punitive damages are already claimed and stated. Fucking hell, this stuff is so... Guys, this stuff is so hard to read when you're used to reading properly formed legal arguments. This stuff is painful to read. Copyright claims against Will Markland and Sean Brennan. My copyright registration with the Law Library of Congress, and he gives this registration number, guys, and this is quite an important little thing here. Registered under the Gorgeous Jaw Show. 3 Laserdisc. Okay, Laserdisc. Laserdisc hasn't existed for a long time. Shows George, he thinks a DVD is a Laserdisc. All of my work under the Gorgeous George Show from 1994 to present. This is a lie. So, George's copyright covers the contents of those 3 DVD discs and those 3 DVD discs only. And that copyright was put into place in 2012. and it covers only the contents of those 3 video discs because George was too cheap to file the correct copyright. He filed a copyright that covers a motion picture only. That's all it covers. It does not cover future works, does not cover previous works. It covers the contents of those 3 video discs only. That's all it covers. And that means he needs to produce those 3 video discs and produce the content that was on them. Got a bit of news for you there, George. You're going to have a problem when you produce those 3 DVD discs, because on those 3 DVD discs is copyright content of people like Dolly Parton and property of Warner Media Group, which you have not paid any royalties to use, and you have therefore breached their copyright. I have today sent letters explaining all of this to Warner Media Group, to Dolly Parton's management, and to every other person that I can find that you have used any of their music without paying them a royalty. And I will make sure that you get a real copyright infringement case to you that demands that you start paying people real money. That I will give you. And that will happen, George. I can tell you that now. 3 Lady Disc solidifies all of my work under the Gorgeous George Show. Fair Use states its claim for newsworthy events, not for stealing one's intellect property and making profit of one's material. Defendant Sean Brennan once made a claim that he took my work to film festivals and made a profit. That claim needs to be answered. Will Markland needs to answer the claims of ongoing issues concerning copyright because most the work is the exact duplicate of my work with a few exceptions. The facts have been given in the original complaint, which was struck. It was struck out, George. The judge has struck out those parts of your original complaint. Exhibits and samples have been previous registered and sent in prior original complaint. Please review prior complaint. All facts and offence have been documented. Motion of summary judgment on defendant Sean Brennan, Rule 56. Since Sean Brennan's had 3 months to answer the claims and hasn't in relation to the third particularised filing, I respectfully request the courts to rule on this defendant with a summary judgment upon the facts of both copyright infringement and amended defamation, all in the body of original complaint. Also, of the previous exhibits given to justify all claims presented in the original complaint. So George here is asking the court to hold someone to a standard that he is not willing to be held to. You're a fucking hypocrite, George. You're the biggest hypocrite in the world. You want the court to hold everyone to a standard that you yourself are not willing to be held to. Prayer for relief. I've stated in claim on both these matters of copyright and defamation, and I've given every claim stated and previously stated my resolve in the matter at hand. I've had to endure this attack for many years, and what I ask for is an reasonable conclusion to be given and reasonable way for justice in these matters from stolen material and cyberstalking. I respectfully ask once again for monetary damages and punitive damages of $40,000 per each defendant and removal of all material off of YouTube. Would be open to any lesser amount upon the judge's opinion of what the law states in the amount and accordance to previous cases similar with the same torts. No matter what anyone thinks about my work or show, I shouldn't be attacked in the way I have. It also shouldn't murk up the decision rendered in the court's decision. I ask for the courts to act accordingly and grant this complaint for the case and move with ruling of copyright infringement and amend the defamation in this matter. Again, I respectfully ask this and hope the facts will speak for themselves with a ruling in my favour. Respectfully yours, Gay. George is the biggest hypocrite on the face of the earth. He demands that people are held to a standard, both personally and in the courts, that this man refuses to be held to himself. He creates attacks on individuals on the internet, and he doxes people on the internet, and quite happily posts their pictures all over his YouTube. He slanders people on a regular basis by saying they beat Japanese children, they beat their mother, they molest children, they're gay, they have sexual relations with their father, and he thinks it's okay for him to do that, but for anyone else to say anything about him, they need to be held accountable for their actions. George, you are about to be held accountable for your actions. You are about to face the wrath of people that have had enough of you. If you think this matter ends purely because you put my name or my alias in a court document, and that I will not proceed on a basis that brings you to account for your actions and brings you to account for the things you have done to people in the last 9 years, believe me, it won't. You will be held to account for what you've done. You are a disgusting human being, and you are someone who needs to recognise that you actually are the mentally ill person, and you are the person who needs to recognise that their behaviour is unacceptable in a modern society. You're a horrible, horrible human being, George Yared, and I will not stop until I have made sure that these videos go everywhere and people see what you really are like. Folks, I have been Muddy McFly. I have been your Swedish attorney at law. This has been another update from the Virginia courts. Guys, if you like the video, please smash the like button, hit the subscribe button, leave your comments. Anything in the comments I'll try and address as quickly as I can do. More videos coming soon. Also, I hope to have some videos released of phone calls with George where he's threatened to shoot me and threatened to kill me when all I've done is phone him up to have a reasonable conversation with him about his actions. Those calls will be released. I've also got text messages to release that prove everything I say and prove what sort of a person George is. All of this stuff coming up soon. Guys, this is Muddy McFly signing off.